If your lordship gives me 5 minutes before my learned friend starts,
Yes.
possibly the controversy can be narrowed down. The learned AG and my lord submissions are going to be that the view of Justice S.C. Agrawal is the correct view. There are two aspects to it. Both majority and minority go into two aspects: immunity, etc., under Article 105, and PC Act when the offence is complete. But I have read the judgment, my lord, fully. Irrespective of the 105, the contours of immunity, privileges, etc., both come to the conclusion that the offence is complete the moment there is an offer for bribe and you accept the bribe. That was the statutory position prior to the amendment of the PC Act in 2017 and even thereafter. Narasimha Rao judgment is prior to 2017. It was amended thereafter in 2017. That is the position. The offence of bribery is complete when I offer money to a member of parliament or a member of assembly, he accepts. Then whether he performs the part of his bargain inside the house or not has nothing to do with the criminality attached. So essentially, my lord, in my respectful submission, it's more a question of interpretation of PC Act rather than, my lord, 105.
But the further question as to whether there is immunity still survives.
Whether it extends or not.
No, my lord, if
Whether, if, because our court has held, the majority held, that irrespective of the criminality, immunity attaches. And the only exception they made was to a person who does not fulfill their part of the bargain, because they said that the words used in 105 are, it's in the past tense.
yes,
Vote given or speech made. So they said if there is no vote cast or no speech made, though the bribe was taken, then there is no immunity. That's why Mr. Ajit Singh had to stand the prosecution.
correct. But my lord, my respectful
So
submission.
we'll have to ultimately deal with the issue of immunity as well,
No, my lord.
as to whether they are right on the broader immunity. And what we have to do is this: since we are sitting as a bench of 7, we need not look at in all the circumstances what is the extent of the immunity enjoyed. We have to decide a very narrow issue. Can immunity attach when there is an element of criminality?
That's
Correct. My lord, only, my lord, it's ultimately my lord's call. But suppose, my lord, the performance of the part of the bargain by the elected member is not relevant. Whether he voted or he did not vote, whether he spoke or did not speak, it may not have relevance because the offence is committed outside the house. Then the privilege, my lord, question may not arise.
No, but then actually you are right. But then we will have to say that the immunity does not attach. That's what you are also saying.
Correct, my lord, correct.
Ah.
But on interpretation
So we
of.
cannot then say that we don't have to go into whether there is immunity or otherwise. We'll have to say if the offence is committed outside, as you said,
Yes, my lord.
then there's no question of the immunity attaching under 105.
Correct. Therefore,
immunity can never attach where there's an element of criminality.
Therefore, the respectful submission is the interpretation of PCA may be more relevant than 105.
That's how we approach it. Actually, you're right. But it's good now. The controversy really narrows down because you're also of the view that the view of Justice Agarwal,
Yeah, yes, my lord.
speaking for two judges, is a more correct view because
Yes,
there
my lord.
was- you had
Someone
Justice,
takes a bribe
Bharucha and
outside the
Justice
house,
Anand.
my lord, and claim immunity.
Justice Bharucha and Justice Anand on the other side, and Justice Ray agreed with them on this issue of immunity, and that's how it became a majority of 3.
I mean, that takes us to a narrow question of a nexus.
But we will even on the question of immunity. So there is now a fair degree of commonality and understanding. We'd like you to assist the court because I mean all your research and your
We have.
the
Well,
vision
we
of
have
lawyers
that.
on both sides will assist us to frame it properly ultimately.
My lord, the only worry, and I'll be very, my lord, very candid, my lord, because of facts of bribery, etc. 105 may not be revisited, except in case of bribery.
Yes, yes.
The Raja Rampal line of judgments, etc. What are the contours?
So you are entirely right because we should not be entering on issues which don't strictly arise before us because the law has evolved in our country by very interstitial steps. You know, there has been some relaxation from the UP case,
Yeah.
then finally Raja Rampal, then we have followed Raja Rampal. So we'll not revisit that, though we are in a bench of 7. Except on the issue of bribery, what arises?
That's all.
Right. In fact,
Because in that case, my lord, the submission would be that inside the house, the legislature would have as much independence as it has, as much, my lord, like, my lord, any other organ of the state.
Absolutely, there's no doubt about it. The whole purpose was to encourage free speech, have an unrestrained dialogue in parliament and in the state legislatures. And that we must preserve. It's a very important part of our nation, the legislature, both in the union and in the states.
and, we are not to be heard saying that bribery is condonable.
No,
May I start, Millets,
Yes, yes.
with a request and a promise, Millets. The request is that if the ambient temperature is increased a little bit, Millets, because we are freezing, we promise to be cool in our arguments, Millets.
Yes, I'll just tell them.
Lordship, please.
Good.
Millets, only for the benefit of Justice Narasimha and Justice Sanjay Kumar, who were not there on the previous occasion, just a few lines of introduction and then I get straight into the matter, Millets. This, Millets, is a regular criminal appeal arising out of a judgment of the Jharkhand High Court declining to quash prosecution against the appellant, who is being prosecuted under Millets, relevant provisions of the Prevention of Corruption Act and the Indian Penal Code for the alleged offense of taking a bribe to vote in a Rajya Sabha election. The appellant was at the relevant time a sitting MLA of Jharkhand. She's alleged to have taken a bribe from an independent candidate to vote for him rather than for her party candidate. But in the event, the vote was actually for her party candidate because that comes out in the open voting. Then there were complaints that election was countermanded. There was a fresh election. And again, she voted for her party candidate, etc. But she was sought to be prosecuted on this allegation. That is how, Millets, the matter arises. Your Lordships are, of course, not concerned with the merits of the appeal just now. I have, in my written submission, Millets, Volume 1, just touched upon the merits only to indicate the nature of the controversy. And we contend, Millets, that we have a strong case on merits. The order granting bail in 2014 passes adverse observations against the CBI, Millets, and the CBI has not appealed against the order granting bail. So, apart from other things, Millets, apart from immunity, I have a strong case on merits, but of course, your Lordships are not concerned with that, Millets. Now, Millets, can I first place the language of the articles, then come to the order of reference, and then come straight to my submissions, Millets.
Constitution convention.
I will read only 105 Millets, not corresponding 194 because they are pari materia Millets. So all my lords have got 105. 1. Subject to the provisions of this constitution and to the rules and standing orders regulating the procedure of parliament, there shall be freedom of speech in parliament. So that is, Millets, subject to the provisions of the constitution. But, Millets, 105(2), no member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in parliament. Kindly note here the word parliament because I'm going to draw a distinction with the second part, Millets, of this provision or any committee thereof. And no person shall be so liable in respect to the publication by or under the authority of either House of Parliament of any report, paper, votes, or proceedings. So the same clause, Millets, of Article 105(2) uses Parliament in two different contexts, Millets. One, Parliament. The other is House of Parliament, and I am going to make a submission on that, Millets, in due course. 3. In other respects, the powers, privileges, and immunities of each House of Parliament and of the members and the committees of each house shall be such as may from time to time be defined by Parliament by law, and until so defined shall be those of that house and its members and committees immediately before the coming into force of Section 15 of the Constitution, 44th Amendment Act, 1978. The provisions of clauses 1, 2, and 3 shall apply in relation to persons by virtue of this Constitution, who by virtue of this Constitution have the right to speak in and otherwise take part in the proceedings of a House of Parliament or any committee thereof as they apply in relation to members of Parliament. Therefore, my learned friend, the Attorney General addresses Parliament minutes, he will also have the same immunity. Now, my lords, may I take my lords straight to the order of reference dated 20th of September. It is, my lords, a detailed order of 16 pages. But for the present purpose, my lords, it's enough for me, my lords. This will be at page 3 of volume 3. Page 3, volume 3 minutes. I'll take my lords straight to page 15 minutes, because the first part minute sets out the nature of the controversy, how the reference was made.
Meetings, right?
Lordship, please, lordship. Has pleadings and orders minutes.
28th of September.
20th to 0 minutes.